This bill is entitled An Act Concerning Consumer Protection and Safety, and I don't think this has anything to do with consumer protection at all. This is more aptly titled something like An Act Interfering with Markets, Denying Freedom, and Destroying Economic Opportunity, because ultimately I think that's the end result of a policy like this. As I read through this bill, and frankly, I haven't read through the whole thing. It was handed to me, earlier today when we became aware that there were a couple of housing sections that were just added willy-nilly at the last minute. And I happen to be the ranking member of the Housing Committee, so I decided I would start taking a much larger peek at this language, and I certainly have some questions and concerns about that. But before I do, I want to talk about some of the other sections just very briefly, just to kind of follow up on Senator Ciccarella's efforts. I guess the first place I would start is in the section about the responsibility for manufacturers to allow individuals to repair products. And I'm the same kind of guy as was discussed here. I fix everything. I have replaced the screen on my cell phone. I used to fix cars, and motorcycles. So I fix my household appliances. I'm totally all about the idea that we should be in a situation to be able to make our own repairs. Repair my own cars to this day. The thing is that doesn't mean that we should deny the manufacturer of a product their rights. And the very simple bottom line on all of this bill is that people own property. And when they own property, it is theirs to do what they choose with it. That's the whole premise behind what's wrong with this bill. Because all throughout this bill, section by section, it is the government coming and telling people what to do with their property. And frankly, I don't think they have a right to do that in any case whatsoever. So certainly if I buy a product and I want to tinker with it, that's on me. But to tell the manufacturer that they have to set up a whole stream of procedures to store inventory and product, and then they have to sell it at limited prices back to the end user is absurd, especially when they are limited in these lines 295 through 299. It says something about the price they can charge is fair and reasonable terms if such manufacturer makes such documentation, parts, and tools available at a price that reflects the actual costs incurred by such manufacturer in preparing and delivering such documentation, excluding any research and development costs. Well, first thing I would say is why excluding any research and development costs? And there are other things that are not included in that figure, like warehousing, the fact that it costs money to put something on a shelf for multiple years to make extra parts that may never be purchased. What if I can't predict the number of actual future parts that are going to be made, so I have to make several thousand extra ones that cost to me and my company, and I've got to put them on a shelf, and then I've got to store it, and then I've got to pay to maintain that facility and keep the lights on and the heat going and paying the taxes on that. Think about all of the additional costs that will be put on the manufacturer in that case. It's an absurd amount. And the way this reads, I don't think that I'm allowed as the manufacturer to be able to pass that cost on to the consumer. I have to only charge the amount for the production of the part and the shipping. And that's ridiculous, frankly. And I go back to, who owns the thing? Whose property is it? If I own anything, I don't care what it is. If I buy it and I own it, then it's mine to do what I want with. And if I choose to sell it, I should be able to choose it to sell it at whatever price that I want to. And if somebody wants to purchase it, that's great. If they don't, that's great too. That's how our system works in America. Free markets, free trade, capitalism, which, by the way, has led to the greatest prosperity in history of any place in all of humankind. We live in the greatest place because of that exact premise, that people are free to exchange goods and services for their own benefit at the prices that they choose. When the government gets involved and starts to dictate the terms at which things are bought and sold, that's no longer freedom, ladies and gentlemen. That is despotism. That is a situation that shouldn't exist in this country, in my view. And speaking of which, moving on to Section 5, this is the section that has to do with price gouging. Let me just say briefly that there's no such thing. That's a term of art for people that want to exploit bad situations to make terrible policy, to take power and control away from free individuals. The language in this bill describes something called unconscionably excessive price. The good chairman said unconsciously excessive price, I think accidentally when he was reading the bill earlier, and I just thought it was funny because, in my view, whoever wrote this bill was unconscious or at least asleep when it comes to the rules of marketplace, free trade, and so forth. Because they certainly don't understand what is happening here. This definition says unconscionably excessive price means an increased price at which a vendor leases, rents, or sells an item during a precipitating event, apparently a storm or an emergency, something of that nature, if the increased price is grossly disproportionate to the price of which the vendor leased, rented, or sold such item immediately before the precipitating event. It goes on a little bit, but the whole point behind this section is to say that if there's a reason why you're increasing the price, maybe there's a big snowstorm and people don't have a way to get snow off the roofs of their houses, etc. And you want to sell roof shovels for snow, which was an issue maybe 10 years ago. That's an excuse to block people from selling them at a higher price. But this type of price fixing does not work. This type of price fixing only causes problems. You know what happens when you tell people that they shouldn't take a risk to stock up on these roof shovels because they are betting that maybe there's a bad storm and they can sell them at a good price later? It's obvious. They don't bother to buy them. Because guess what happens then when the storm happens? There's none of those shovels available at all. So what you're doing is you're messing with the marketplace. You're creating scarcity. You're creating artificial shortages. You're discouraging emergency response. The government and this type of law can never react as fast as the marketplace. Trust me when I tell you, if there is a shortage of anything like there was during the pandemic, whether it is toilet paper or paper towels or even surgical masks, guess what happens? Somebody in the marketplace finds a way to get those masks produced and to the customer. But writing a law that says, no, there's no way for you to make money because it's terrible or somehow unseemly or immoral to make money on the fact that there's a crisis. The fact is that when that happens, the problem gets solved. When the government price fixes, the problem goes unanswered. That's what's immoral, frankly. It is a direct violation of contract rights. Having terms such as unconscionable or excessive, those are vague and subjective terms. And in this bill, we're empowering one man, whoever the Attorney General is at the time, to decide what's unconscionable or excessive. What kind of system is that? Where one person gets to be the arbitrary decider of whether or not you're charging too much for a product. Because you bothered to be prepared, because you bothered to think ahead. And you said, you know what? The next time there's going to be a pandemic and people are going to need these things, I'll tell you what, I'm going to take an economic risk and stock up on those things so that I'm prepared when it happens. Don't we want people to do that? Don't we want people to be prepared when there's a crisis so those products exist? So that the vaccine that's necessary is actually out there and in production? That the masks are actually available? That you can get TP? Seriously. You start passing laws like that, and guess what happens? In those types of events, what you get is people will hoard them, for one thing, and they will not be available. They will take too much. Do you remember people during the pandemic going and buying all the toilet paper off the shelves? That's what happens. Let the marketplace work is the lesson that I am trying to explain. There's a lot more to say about the rest of the bill, but because Senator Ciccarella did such a good job going through the first several sections. I'm going to just come around to what he advertised I would talk about, which is the last couple sections. And first and foremost, I would say these are sections that have directly to do with housing. We have a committee of cognizance in this legislature about housing. And this legislation should go through that committee, in my view. It shouldn't just get dumped into some random amendment to end up in another bill, because the majority can. Just this past week, I have heard several times that amendments offered by the minority could not be honored, they couldn't be supported, based on the simple fact that, well, they never got a hearing, Senator. Just a reminder that the majority decides what bills get a hearing to begin with. So when they say, well, it didn't get a hearing, well, it's because you wouldn't give me a hearing on my bill. All I got is the amendment practice. But here it is. It's obviously okay for the majority to put anything they want in any bill, anywhere, at any time. So I'm using this opportunity just to remind them that their hypocrisy is extremely clear and on display in this particular bill on this particular topic. So let's talk about Section 9, which extends this weird concept of all-in pricing to housing. Housing is an entirely different thing. Let me start with that. You know, if you're selling TVs or you're selling vacuums, or even if you're selling certain types of services, it's pretty standard. You know, anybody who's going in to buy a TV is getting the same price because they're buying the same product for the same use. But when you're renting property, and you could be renting property for lots of reasons, by the way, but if you're going to rent property, everything's negotiable. Same thing in a purchase. I'm a real estate agent. I've been in, hundreds of transactions, and everyone's different. You can't put two transactions next to each other and say they're the same. They all have different exceptions. They have different conditions because the circumstances are always different. The timeline for the buyer, or the level of inspections that we want to have, or the arrangements for financing. And that's all true at a purchase, but a lot of that same stuff holds true in a rental. Going to rent a house to someone. Well, are you going to use the garage? Yes or no? Oh, well, that's different. We're going to say, okay, we're going to include the garage. Oh, you only want to use the garage for 2 months? Okay, we'll have to write that into the lease document. Do you want to leave the place furnished or unfurnished? Oh, well, Rob, I love the living room furniture, but do you mind getting rid of the other stuff because I'm going to bring my own? My point is that this is not a cookie-cutter, cut-and-dry thing that we can have the Department of Housing slap together on a one-sheet form. Oh, it's done. And we can't expect either the tenant or the landlord to be able to subject themselves to this cookie-cutter, all-in pricing scenario when it doesn't work like that. It's a private contract. Since the beginning of this great country and before, people have been engaging in commerce, buying and selling goods and services on their own in good faith without any need for the government to create a form. The government has only one role in that transaction, just one, and that is to make sure that if the parties don't live up to the terms, there's a mechanism to enforce the terms. That's the only obligation the government has. All of the other things that government has decided to do along the way to interfere, to say, well, you can't put this in your contract, you can't put that in your contract, oh, if you're going to do this, you have to include all-in pricing. All of that is unnecessary. It is interference. It messes up freedom between the parties. The same freedom that I mentioned earlier, which is the source of our great success as a nation. Frankly, they just don't have any business. If you have a landlord and a tenant, and they are negotiating the terms of how they're going to work their business arrangement, let them. Let them figure it out. We have all kinds of rules. You know, how much the security deposit can be, whether or not you can take more than 1 month's rent. All of that interferes with the freedom of the parties. And you know what? The majority is always responsible for these changes based on the same argument. It's a tired and flawed argument that somehow they're protecting someone in the transaction. And this bill's no different. This is about protecting consumers. You cannot protect consumers by denying their freedom to negotiate. That is not protecting them. Let's talk about this. Can I ask why, through you, Madam President, why in Section 9 we have a requirement? Well, first and foremost, let's just ask the more basic question, which is why is all-in pricing supposedly superior to allowing the landlord and the tenant to work it out themselves? Through you.
Thank you, Senator Maroney.
Through you, Madam President, thank you to my good colleague, for the question. The plan is to put everything on a level playing field, and so that people can make those comparisons to make the well-informed decision, and that's why we are looking for all-in pricing for a number of different areas. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the gentleman's answer, and I don't mean to be disrespectful, but we always hear these canned terms. Well, they're on a level playing field. No, they were on a level playing field when both sides had the opportunity to negotiate the terms between themselves. When the government comes in and says we're going to require something of one party and not of the other party, they are no longer on a level playing field, for clarity's sake. Is there a benefit to either party by having all-in pricing, and what is that benefit? How does it actually improve the station of the renter? Because presumably that's what it's about. Through you.
Thank you, Senator Maroney.
Through you, Madam President, there may be a theoretical case where you have a renter who can only afford to pay $1,500 or so a month. They see the advertised price is $1,500. They go to sign the lease and realize that it wasn't actually $1,500. There were additional fees that were part of it, and they could not afford that. So they may not have gone to even look at that or wasted their time or perhaps the landlord's time. But if they knew the actual final price, it would be more efficient for them. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I can tell you that I've advertised many rentals over the years for myself and for my clients, and I will tell you that we generally try and put a fair price on a rental for what we're hoping to achieve as far as a circumstance. But I think most people recognize that it's negotiable. Just like if you go to buy a house and they're asking, $299,000 for it, I think everyone knows that they can offer $275,000. Maybe the seller takes it, maybe they don't. Maybe you negotiate, there's something in the middle. But in almost every transaction I've ever done for a sale or a rental of real estate, it's been understood there is a negotiation. When the person comes out to look at the property, we have the conversation about whether or not you're going to use the entire property, what the term is for the rental, whether you're going to stay for 3 months or 6 months or 5 years. I think it's understood that it's negotiable and that clearly the price will change based on any of those parameters. So I don't understand how we can write a statute that says that the landlord has to put a fixed price when nothing's fixed. Everything is negotiable. I don't want to drive the good chairman crazy by asking him about these questions, but he's welcome to interrupt me. But I'm sure he would confirm that there's nothing stopping someone from renting a place for, a day, as in a short-term rental, or having a 10-year lease, or for 11 days, or 45 days, or 206 days. It doesn't matter. Anything can happen. Or you can rent the entire building or part of the building or the garage or not the garage or half the year of the garage. None of that is fixed. And the requirement in this bill is that the sale price is fixed. And the problem I have with this is I get the idea that we're not trying to mislead a prospective tenant about the price of the apartment. But I don't think landlords are trying to do that anyway. Because frankly, I think when you attempt to mislead someone about the price, that doesn't do you any good as the seller or lessor, frankly, because you want someone to come to an agreement with you. So if I'm really going to rent my apartment for $1,500, why would I advertise it for $2,000? That doesn't make any sense. So the whole premise this is built on, I don't think makes any sense to begin with. And the danger here is that there's a penalty in this bill. There is a penalty attributed to this bill that says any landlord, it's on 926 through 929, who violates the provisions of this section shall be liable to the tenant for a civil penalty in the amount equal to 1 month's rent, and the court may award reasonable attorney's fees and costs to the tenant as well. I could ask a lot of questions about how we get to that point. Who puts in the claim? How do they justify a claim? Is it automatic that if you can come to the housing court and you can show that that landlord advertised the place for $1,500 a month, and then you show that the lease came out to $1,575 a month, is the landlord automatically guilty in that case? Through you, Madam President?
Thank you, Senator Maroney.
Through you, Madam President, they would not be automatically guilty. Through you.
Thank you, Senator Sampson.
Thank you very much, Madam President. Well, thank heavens for that. And what would be the reason that they wouldn't be automatically guilty in that case? Through you.
Thank you, Senator Maroney.
926. Through you, Madam President, they would have to go, it appears that they would have to be adjudicated in the court.
Thank you, Senator Sampson.
Thank you very much, Madam President. So the landlord might have to go to court to defend themselves because the ultimate contract ended up being a different amount than their advertised price. And this General Assembly would have created a law that basically implies to the tenant that somehow they can go to court to challenge their landlord over that circumstance. Is there a way in which the landlord would not be responsible because of any of the circumstances I've already mentioned? Like, you know, they negotiated a different price because they had listed the rent at $1,500, assuming that the typical tenant might want to rent the place for a year, but this person came along and said, I only want to rent it for 6 months. And after some negotiation, they came up with $1,575 as a compromise. You pay me a little more since you're only going to stay 6 months and you're going to be moving out in the middle of winter and it might be harder for me to get a new tenant. Is that a situation which the good chairman would perceive that the tenant has a case, or the landlord would be safe? Through you.
Thank you, Senator Maroney.
Through you, Madam President, that is a case where my assumption is that the landlord would be safe because it would be based on different terms than were advertised, a different term of length of the lease. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President. I appreciate the gentleman's assumption, but can you show me in the bill where the landlord would be safe? Through you.
Thank you, Senator Maroney.
Through you, Madam President, this does not require that the price be fixed. This is a disclosure bill. It just requires that any mandatory fees are included on the form as developed by the Department of Housing. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I'm going through this exercise of creating this scenario because I want us to have this conversation about how this actually is going to play out in the real world. Because we're not just arguing some philosophical thing here, which I like to do, clearly, but we're also arguing over what's going to happen if this bill becomes law. And I want to actually have the conversation to understand what happens when the rubber meets the road. This is a real thing. We got a real tenant who's making a complaint against the real landlord. They negotiated in good faith. They adjusted the rent upwards slightly because the person negotiated a shorter term of rent. And now it's before the housing court. And the housing court is going to decide based on this statute. So what in this statute allows the landlord to be safe? Through you.
Thank you, Senator Maroney.
Through you, Madam President, there are certain fees in here that are not required to be included if they're variable. So, and cost of the So they are not required, we have no such fee. Without including the following fees and costs: any payment processing fee, any fee or deposit imposed for keeping a pet, the cost of any utilities if they are sub-metered or the tenant pays them directly to utility company, a fee charged for damage to the dwelling unit, a separate fee charged for performing a service for the tenant, including but not limited to responding to a lockout or replacing a key. So there are certain exceptions to what are there. We just require that our mandatory fees are disclosed. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the good senator reading from the bill about the other items that are itemized. But I just used the example I did to make it as simple as I possibly could. I didn't want to go down that road. I was actually trying to keep this as simple as possible, because the only thing that's changed really is the actual rent. That's it. That's in my scenario. We're not talking about something confusing. I mentioned 100 things, and there are probably 1,000 more that could be negotiated in a circumstance which might end up in this particular bill that could be debated in a court situation. I'm trying to pick the simplest one that you could imagine, which is they simply change the amount of the rent, which to me is the number one fixed all-in cost that is ascribed in this bill. And frankly, and no disrespect, but you didn't answer my question. You gave me a list of items that are attributed in the bill, but not a reason why the landlord could be safe after a good faith negotiation by both parties. I don't want to put you on the spot again, Mr. Chairman, but if you give me a sign that you've got something to share, I'm more than happy to pause and let you make your case.
Through you, Madam President, on lines 887, they shall be required to pay on a periodic basis. So they're only required to include those fees that shall be required, but nothing in here prohibits negotiating. It's a disclosure. Through you, Madam President.
Thank you, Senator Sampson.
Yeah, I didn't hear the line number through you, Madam President. Can the good gentleman point it out to me?
Through you, Madam President, line 885.
Senator Sampson.
Oh, line 885.
Yeah, I'm sorry.
Yeah, this is the beginning of Section 9. I'll just accept as provided in subsection B, which is another thing we could talk about, but no landlord shall advertise, display, or otherwise offer a dwelling unit for rent in an amount that excludes any fee, charge, or cost that the tenant of the advertised, displayed, or offered dwelling unit shall be required to pay on a periodic basis. Okay, so if I advertise my unit for $1,500 a month, it's implied that it's for a yearly rent, but the tenant says, well, you know, I'm going to end up, by the way, I'm going to be doing some extra stuff out of my house that's going to require me using a lot of water, you know? I know the water is included, and we figure it out. Or just simply, I mean, I don't want to complicate the issue. Let's leave with the 1575 because we went to a shorter term lease. That is included in that sentence. That is the exact thing that's in that sentence. And then it goes right to the penalty. So it sounds to me like this bill sets up a situation where that tenant can go right to court and say, it said $1,500 a month, my lease says $1,575, I'm now mad at my landlord, I want restitution for that. And now, not only does the landlord have to obviously fix that, but he's going to have to give them back a month's rent and legal costs. And think about that for a second. There's no skin in the game for the tenant, basically. It's only the landlord is going to have to eat the costs. This is one-sided. Remember, this is a level playing field, Senator. It is not a level playing field. This is government interference, picking and choosing which side of a formerly free negotiation the government wants to land on. Let's move on here. There's another section in here which I think is remarkably unfair. It's lines 897 to 900. Oh, no, I'm sorry, that's not it. I'm looking for the part that says that money has to be applied to rent first. Oh, I see it right there. It's the highlighted part in my notes. No wonder I couldn't find it. It's because I'm in the 7-10 split for the last several days here. It's a hard shot to make. So let me just say, lines 923 to 925. All payments made by a tenant pursuant to a rental agreement shall be applied first toward the payment of rent and then toward the payment of any other fees or charges. So through you, Madam President, I have a tenant who has not paid their rent on time in the last 3 months, and they've accrued 3 months of late charges. And I really want them to get caught up on their late charges, and I'd also like them to pay their monthly rent on time going forward. How does this work? If my tenant only pays me a fraction of the rent again this month, will they technically be late? And can I apply that money towards the late charges that they've already accrued through you?
Thank you, Senator Maroney.
Through you, Madam President, the money would, in your example, I believe it would be first applied towards their late rent before it was applied towards their late fees. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. So they would have, what if they paid enough to pay off their late rent but not their late fees? And there's $100 left over. What happens there? Is that money applied to the current rent, or is it applied to the late charges that have already been accrued?
Senator Maroney.
Through you, Madam President. Thank you for the question. I just want to ask a clarifying question, if I may. So you're saying they were 3 months late on rent. They've gotten caught up on the 3 months of rent, but not all of the late fees. And would that extra $100 go towards the next month's rent first or towards the late fees? And is that current month's rent due and payable or not yet? Through you.
Thank you, Senator Sampson.
Thank you very much, Madam President. I'm glad that we've got the scenario, I think, very, very clearly stated. And yes, the current month's rent is due payable right now. My tenant made a payment to get caught up on their previous month's rent, but they still owe me $50 3 times for the last 3 months because they haven't paid that. And now I have a, they make the payment and I'm left with $100, but I have this month's rent is due and I still have the 3 outstanding late charges. What happens? Through you.
Thank you, Senator Maroney.
If, through you, Madam President, thank you for the question. If that month's rent were due at the time, that $100 would be applied towards the rent first, so they would still have those late fees. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Given this example, and again, this is a very mild example because people could become very late with other types of fees and late charges. I'm just talking about 3 measly months, okay? But in this particular example, can I ask you how the landlord has any hope of ever getting paid for those late charges?
Thank you, Senator Maroney.
Yeah, through you, Madam President, I believe that would be through whatever normal process you would go after late rent, through small claims courts or in other ways collecting. Through you.
Thank you, Senator Sampson.
Right, so here we have a situation where the tenant is purposely not paying the fees that have been accrued for being late because we've created a law that means they don't have to. Because as long as they keep paying towards their monthly rent, they know that their payments will go towards the rent and not towards any other charges they've accrued, effectively creating a situation where the tenant can be rent late every month without ever facing any type of penalty. That's what's created in this situation. But what's worse than that is that I fear that what could happen is if somebody's late for several months, they don't pay their rent or they don't pay their late fees, when they make a payment, this bill implies that they have that payment applying to their current month rent. Is that correct through you, Madam President?
Thank you, Senator Maroney.
Through you, Madam President. Yes, that's my reading of the bill as well.
Thank you, Senator Sampson.
I hope everybody was listening. So you got a tenant that doesn't pay their rent to their landlord. Remember, the landlord still got obligations. They still got to pay their taxes to the town. They still got to maintain the building. They still have got to make their mortgage payment. They have obligations too. Not every landlord's a giant corporation with mountains of money. In fact, a great many of them are people that are just getting by. They're family landlords. They own one property or two properties, or in fact, it's a two-family house and they're renting out part of it to help them pay their monthly bills. We are going to be passing legislation here that allows a situation where tenants can take advantage of their landlords by law. Can you imagine? By law. Because as long as you can manage to get some amount paid to your landlord on a monthly basis, it doesn't matter how late you are, that landlord can never say that you are late on your rent. Because you're paying money that is applied to the current month. Madam President, can I ask the good chairman how this interacts with our housing laws that already exist in housing court? If a landlord becomes desperate because they can't afford to pay their bills because the tenant's not paying their rent, can they go to court and say, I want to evict this person for non-payment of rent under those circumstances?
Thank you, Senator Maroney.
Through you, Madam President, yes, they can.
Thank you, Senator Sampson.
Thank you very much, Madam President. And can the good chairman explain to me exactly how that could be a legitimate case? The landlord accepted payment, and that payment was applied to the current month's rent.
Thank you, Senator Maroney.
Through you, Madam President, there is nothing in this bill that states they could not access the housing court if, for whatever reasons, they could normally access the housing court. Through you, Madam President.
Thank you, Senator Sampson.
Okay, that sounds good. Thank you, Madam President. I apologize. I was distracted talking to another member. A very interesting debate we're having. Obviously, there's a lot of folks that want to weigh in. Would the gentleman be kind enough to repeat the answer? Through you.
Thank you, Senator Maroney.
Through you, Madam President, nothing in the bill prohibits you from accessing the housing court if there is rent for under the normal, under any normal circumstances which you would have previously accessed the housing court.
Thank you, Senator Sampson.
Well, thank you very much, Madam President. I think that's obvious. I think everybody in our society knows that you can sue anyone for anything. The question is whether or not you would prevail. And is there anything that we're discussing that, and I'm asking in good faith, Mr. Chairman, do you think based on this change that someone might have a harder time as a landlord prevailing in a case saying that their tenant is late if we've created a statute that says that rent payments have to be applied to the current month's rent? Technically, that person's not late. Through you.
Thank you, Senator Maroney.
Through you, Madam President, it would apply to the previous rent that was owed, and then it would be applied towards the current month. So if they were behind, you would still be able to. And I do acknowledge that it probably is different than the process was before. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. This is all I'm trying to point out, is that this bill is utterly unfair to one side of what was formerly a equal, level playing field transaction. Now it is no longer an equal, level playing field. It is the state intervening on behalf of one side of the transaction to set up much more difficult circumstances for the other party to be compensated. That's what's happening here. And even if you come down on the side of the tenant and you look at this and you say, well, this is an excellent protection for tenants. We should have these things because landlords are mean people that take people's money and housing is a right and all those things that you believe in. And I can completely understand people coming from that perspective, but even if you believe that, I want you to understand what happens in the real world. When this bill passes and landlords are faced with these new circumstances, I can tell you that if you're a borderline tenant, Your credit's maybe not so good. Your payment history's not so hot. Your job history isn't so current. Guess what? You are far less likely to find a rent now because landlords are going to be that much more particular about who they rent to because they will have to be. There's no more kind and gentle landlords giving someone a chance because they can't. Because frankly, this state government is setting up rules that make it so arbitrary and capricious in favor of the tenant that you can't possibly survive playing by these rules unless you are extremely particular. So the very people that would advocate for this type of policy are the very people that will suffer as a result of it. Make no mistake, when you lean on the housing provider and make it more difficult for them, they are going to be a lot more hard on the potential tenants that they deal with because they have no choice. Every action has a reaction. And when the government interferes in a private marketplace and upsets the delicate balance that allows the industry to react and adjust, the industry's still going to react and adjust, just not in a favorable way. I got one more piece of this thing I want to talk about really quick, and that is lines 909 to 922. These lines say that the Department of Housing, which is a state agency in the state, shall publish on the department's internet website a standardized rental terms summary form. Then it goes on to say that this form shall summarize the key terms of a rental agreement. And of course, none of that's laid out in this bill. All it is let's go enable the bureaucracy to create something. Something else we should also be very, very wary of doing all the time. With not putting things in law, we're going to tell someone else that they'll decide. There's been this high frequency of bills that allow the subjective decision of some single person in our government. Yesterday, we had a labor bill that allowed the labor commissioner to decide whether or not to prosecute someone and stop payment for them. And then it said the comptroller has a right to decide whether or not to actually follow through with what they said. And this one lets the Department of Housing determine what's going to be in this form. We should decide what's in the form if there's a form to be created, in my view. But more importantly, this form doesn't need to exist. But not only will this form be created by the Department of Housing, but in every case, every landlord will have to provide this form in addition to the lease agreement that they work out with their tenant, which presumably includes all of those other terms. What exactly is the benefit of this document? Through you, Madam President.
Thank you, Senator Maroney.
Through you, Madam President, this is intended in a way to be like a nutrition label where you know the information, where you can find the information. Similar things had been done on college financial aid packages so that people would know and be able to make straight comparisons. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Nutrition label. This is a gluten-free lease, ladies and gentlemen. I can't believe the way this place operates sometimes, frankly. We don't need a nutrition label for rental agreements. We don't. The lease is the nutrition label, if we're going to use that metaphor. The lease has the terms. It says the dates. In fact, I will venture to guess that the vast majority of leases, if we grabbed all the leases up all across this Connecticut, written by every person we can find, I would say in the first 5 lines, it's going to say the term of the lease, the parties of the lease, and the monthly rent. I bet you it's in the first 5 sentences in 99% of cases. Why we would need another separate document to put that information in only clouds the issue, in my view. Is there anything binding on the landlord or tenant for what's on this Department of Housing document if it in some way differs from the actual lease? Through you.
Thank you, Senator Maroney.
Through you, Madam President. No, this is just they have to disclose all of the mandatory fees, and the form will be developed giving the key terms of the rental agreement and the other things that will be necessary on the firm, such as the name of landlord, point of contact for property management purposes, et cetera.
Thank you, Senator Sampson.
And thank you very much, Madam President. So I can put anything I want on this document, and it doesn't matter through you, Madam President?
Thank you, Senator Maroney.
I apologize. Would you repeat the question?
Senator Sampson.
Thank you, Madam President. I asked whether or not there was anything binding about this separate document, and if there was a conflict between the information placed on that document and the actual lease document signed by the parties, whether either party could use that as a mechanism to make a claim against the other party. Through you.
Thank you, Senator Maroney.
Through you, Madam President, no, there is nothing. This document is not legally binding. Through you.
Thank you, Senator Sampson.
And thank you very much, Madam President. And you gave me the same answer you gave me a moment ago. Well, there's nothing binding. So I followed up with the question, so that means I can put anything I want on this document. Because clearly it doesn't matter. Am I correct about that? Through you?
Thank you, Senator Maroney.
Through you, Madam President, it would matter in the event that if you did not disclose all of the mandatory fees and then ended up in your lease charging more, then that would matter. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I hope anyone who's been watching this debate understands that the minefield is just getting more and more littered with danger. That's what's happening. Well, first it was, well, the all-in price, well, but everything's negotiable. What if the rent changes? Oh, well, yeah, of course they can go to housing court. Well, would they have a better or worse chance to prevail in a case? Well, maybe they'd have a better chance because this law now does this. Well, and now if there's a conflict between the document, it doesn't matter at all until it matters. Until somehow now the Department of Housing is fining you because you failed to provide this document or there was a conflict in this document. And then the way I'm reading this, it leads to the section that says that, boy, you may end up in court and have to owe your tenant a month's rent and then attorney fees and so forth. There's a lot to go over here, Madam President. I don't want to keep belaboring this. I think I've made my point very clear, which is that we're interfering with a private agreement that there's no need to interfere with. I think the vast majority of the disputes that end up in housing court are not about these things. Usually, it's because one party or the other flagrantly violated the agreement that they made in writing to one another. They either didn't pay their rent, or they wrecked the place, or the landlord failed to provide some sort of item that is required by the lease terms. And that's all we need. And all we need our government to do is to be there to adjudicate that situation that was freely negotiated by the parties. What we don't need is busybodies. What we don't need is micromanagement or government coming along to tell people what terms belong in that document. It's none of their business, frankly. That's between the parties. I have an amendment on this proposed bill, but I know that we are in the middle of debating an amendment, so I'm going to suggest to my colleagues that we vote no on this amendment, and then I'd like the opportunity to maintain the floor so I can offer my amendment. Thank you, Madam President.
Thank you, Senator Sampson.
Thank you to my colleague. After we proceed, I think we'll be continuing our conversation. Before we vote on this, I want to request that the vote on this amendment is taken by roll. In addition,
Amendment A of Senate Bill 3. Total number voting 35, total voting yea 25. Total vote nay 10, absent not voting 1.
The amendment passes. Will you?
Thank you very much, Madam President. As I mentioned before we voted on the underlying amendment that is now the bill, I mentioned that I had an amendment to offer, which I will do so in a moment, but I have an issue came to my attention while we were voting, and I've been asked to see if I can get legislative clarity on a couple of sentences that appear in the bill, and that is in lines 704 through 710. There is some new language that describes the requirement that a company provide notice to a consumer that they are on a monthly billing plan. I guess it's more like a confirmation. So I've been asked to confirm that for the purposes of legislative intent, that in those lines 704 to 710, that one billing notice with the terms of their agreement annually shall meet the requirements in that section. Through you.
Thank you, Madam President. For the purposes of legislative intent, that is correct. And it's line 706 and 707. It says an annual, it shall send to the consumer an annual reminder. So once a year is correct. Thank you very much for that question and for clarifying that. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President, and I thank the chairman for clarifying that. I'm glad we got that out of the way. I won't rehash the conversation that we had before the vote. I will just suggest once again that the sections 9 and 10 that have to do with housing really don't belong in this bill. In fact, you know, these sections did come up in the committee for a hearing, but they were never voted upon. The chairs of the committee did not bring this forward for a vote. And for me, that is very telling. They know that they would have faced an obstacle clearly in the committee over this language, and for it to just simply show up as an amendment on an unrelated non-housing bill, to me is irregular. And obviously, I don't agree with the policy. I think I've made it very clear that I think that the policy is punitive and arbitrary. And for those reasons, Madam President, I have an amendment. And that amendment is LCO 8607. The clerk should be in possession of that amendment. I ask that it be called and I be given leave of the chamber to summarize.
Thank you, Senator Sampson. Oh, sorry, we got to get the amendment up. Sorry, my microphone button isn't working well.
LCO number 8607, that would be Senate Amendment B.
Senator Sampson.
Thank you very much, Madam President. This is a very simple amendment. It's a sentence, basically, and what it would do would be to strike sections 9 and 10 of the bill, which are the offensive sections regarding housing that I don't believe should have been added to this bill that is before us. This would strike those in their entirety. I move adoption, and I'd like a roll call vote when the vote is called. Thank you.
Thank you. We will have a roll call vote. Senator Maroney.
Thank you, Madam President. I appreciate the amendment from my colleague. I understand from him what you had said. They did not receive a hearing in the Housing Committee. These amendments actually did receive, these sections actually did receive a hearing within the General Law Committee. They come from sections 3 and 4 of Senate Bill 1248, which was the governor's bill. And so this bill combines sections of 3 different bills that were within the General Law Committee. So with that, I would ask my colleagues to reject the amendment. Thank you, Madam President.
Thank you. Will you remark further on the amendment? If not, the machine is open. Mr. Clerk.
Media roll call vote. Senate Amendment B of Senate Bill 3. Total number voting 35. Total voting yea 11. Total voting nay 24.